equality, specifically race discrimination in higher education. Last year, the Department of Justice sued Yale University for discriminating against students on the basis of race. Based on Yale's own data, if you look at one of its top academic categories when you control for academic achievement, the admission rates by racial category were as follows. Asian Americans, 6%, white applicants, 8%, Hispanics, 21%, African Americans, 49%. Do you think that evidence suggests discrimination based on race in Yale's admissions process?
So again, my best recollection is that between my nomination and now, the department has made a decision about that.
The case was voluntarily dismissed on February 3rd. It's no longer a pending case.
So my recollection is correct. So these kind of cases obviously depend on application of the Supreme Court's opinion in the Gritter case and the Fisher case. And they require a lot of factual development and examination of the facts. These cases do not only depend on disparate statistics, but on all the factors the Supreme Court instructed the lower courts and the government as to what kinds of affirmative action in higher education are permissible and which ones aren't. So I honestly can't draw any conclusions without knowing the facts of the case.
So some of that Supreme Court case law about racial discrimination in higher education says that race can only be used as a plus factor. It can't be decisive in practice. It can't be a defining feature. It can't be the predominant factor. When Asian American kids are 8 times less likely to be admitted in the same band of academic achievement, you don't think that at least suggests a facial case of racial discrimination?
Well, I think that's the question that you look at for the underlying facts to know. I don't remember exactly the words of the Supreme Court opinions, but they seem pretty much exactly, what you just said. You can't have a rigid quota. You can't have a fixed. This was the consequence of the Gratz case, which was the companion case to Gritter. Gritter was the University of Michigan Law School. Gratz was University of Michigan as a university. With respect to Gritter, the court said it was a holistic approach and was permissible. With respect to Gratz, it said it was a fixed ratio or a fixed number and not permissible. But those are things you find out by discovery in the case and examination of what the actual practices of the university were, and I have no idea what they were.
Judge, did anyone in the Biden administration consult with you about the decision to drop the lawsuit against Yale University?
No, I have assiduously kept out of those. It's not appropriate for me to be examining anything like that unless you confirm me.
Will the Department of Justice, under your leadership, pursue cases of obvious racial discrimination in higher education?
Well, if you put it that way, the answer is, of course, yes. Obvious.
Well, I think this presents an obvious case of discrimination against Asian Americans. I suspect some Asian American parents and their kids are a little disappointed in those answers, Judge. I want to turn to the...
I just want to say I'm only giving the answer what the Supreme Court said the law was. I can't do any better.